A federal courtroom erupted into absolute bedlam this afternoon when Donald Trump's already fractured legal team descended into open warfare during what was supposed to be routine pre-trial proceedings, with lead attorney Emil Bove and co-counsel Alina Habba engaging in heated argument in front of Judge Tanya Chutkan about trial strategy, with Bove attempting to exclude Habba from cross-examining witnesses due to her lack of criminal trial experience, while Habba accused Bove of sabotaging Trump's defense through incompetent preparation and refusal to pursue aggressive tactics that Trump himself has demanded. The extraordinary courtroom meltdown, which occurred during a sidebar conference that became so heated, and Judge Chutkan was forced to call a recess and to hold an emergency sealed hearing in chambers about the defense team's dysfunction, represents the culmination of weeks of escalating tensions within Trump's legal operation as attorneys struggle to manage simultaneous impeachment proceedings and Supreme Court disqualification litigation and criminal trial, while facing inadequate preparation time, conflicting strategic visions, and constant pressure from Trump himself, who has grown increasingly frustrated with his team's performance. And this isn't some minor disagreement between co-counsel about tactical questions that typically arise during complex litigation and that attorneys resolve through professional discussion away from the courtroom. This is Trump's lead trial attorney and a prominent member of his defense team engaging in shouting match audible to reporters and spectators in the gallery, with accusations of incompetence and sabotage being exchanged in front of the judge presiding over Trump's criminal trial, demonstrating that Trump's legal defense has collapsed not merely in terms of strategic effectiveness, but in terms of basic professional cohesion necessary to mount any credible defense. When defense attorneys for a defendant facing the most serious federal criminal charges ever brought against a former president cannot maintain professional decorum during court proceedings and instead air their conflicts publicly in ways that undermine their client's case, it signals that the defense has reached terminal dysfunction, or even basic representation has become impossible, regardless of the legal merits. Hit that subscribe button right now, because you won't want to miss any of the videos I release. So what specific trigger caused today's public breakdown, and what did the attorneys say to each other during the confrontation? According to reporters who were present in the courtroom and who could hear portions of the sidebars through the white noise system designed to mask such discussions, the conflict erupted when Judge Chutkan asked the defense team which attorney would conduct cross-examination of the afternoon's scheduled witness, former Vice President Mike Pence, who prosecutors plan to call to testify about conversations where he told Trump that the proposed plan to reject electoral votes lacked constitutional authority and would violate Pence's oath to the Constitution. Bove responded that he would conduct the cross-examination as lead trial counsel, but Habba immediately interjected that she should conduct it because she has established rapport with Trump and understands his defense strategy better than Bove, who she claimed has been timid and ineffective in previous cross-examinations. Bove responded sharply that Habba has no criminal trial experience, that her confrontational style is counterproductive with judges and juries, and that Trump specifically hired Bove to serve as lead counsel because of his federal criminal trial experience. Habba fired back that Bove's allegedly superior experience has produced nothing but disaster, citing the disastrous first day of trial where Judge Chutkan interrupted Bove's opening statement multiple times and where Bove's cross-examination of Pat Cipollone reinforced damaging testimony rather than undermining it. The exchange escalated from there, with voices rising and with both attorneys gesturing emphatically, prompting Judge Chutkan to intervene and to order both attorneys to stop immediately. Judge Chutkan attempted to restore order by asking the attorneys to submit in writing by end of day which attorney would conduct the Pence cross-examination, with explanation of each attorney's qualifications. But Habba responded that she didn't need to justify her qualifications to the court or to Bove, that Trump wanted her to handle key witnesses and that she would not be excluded from examination by someone whose incompetence had already damaged the defense beyond repair. Bove responded that he would not allow Habba to destroy what remained of Trump's defense through amateur cross-examination, and that if Trump wanted Habba to handle witnesses, then Trump needed new lead counsel because Bove would not participate in malpractice. At that point, Judge Chutkan called a recess and instructed both attorneys to join her in chambers, along with the prosecutors telling the courtroom that proceedings would resume after the defense team resolved its internal disagreements in a manner that would not further disrupt the trial. The sealed chambers conference lasted approximately 45 minutes, with sources familiar with the discussion reporting that Judge Chutkan expressed serious concerns about whether Trump was receiving adequate representation given the apparent dysfunction within his legal team. The judge reportedly asked Bove directly whether he could effectively represent Trump given the conflicts with co-counsel, and asked Habba whether she believed Bove's continued participation as lead counsel served Trump's interests. Both attorneys reportedly toned down their rhetoric during the chambers conference, but maintained their substantive positions about who should handle key aspects of trial. Judge Chutkan ultimately ruled that Bove would conduct the Pence cross-examination as lead trial counsel, but that Habba could participate by suggesting questions through written notes and could conduct redirect examination if Habba's cross-examination left issues unaddressed. The judge warned both attorneys that any further public disputes would result in sanctions and potentially in removal of one or both attorneys from the case if their conflicts prevented Trump from receiving adequate representation. Smash that like button if this is making sense so far. Here's where the situation becomes absolutely critical for understanding how defense team dysfunction affects Trump's case and his prospects at trial. The public breakdown between Bove and Habba is symptomatic of deeper problems within Trump's legal operation that have been building since the sanctions that removed his previous attorneys just weeks before trial began. Trump has struggled to maintain stable legal representation throughout his various legal challenges, with attorneys either withdrawing due to conflicts with Trump over strategy and fee payments or being removed through sanctions for misconduct. The current team was assembled hastily after the sanctions left Trump without trial counsel, with Bove brought in for his federal criminal trial experience and Habba retained because of her prior representation of Trump in civil matters and her willingness to adopt Trump's preferred and aggressive confrontational approach. However, the fundamental incompatibility between Bove's experienced professional approach and Habba's aggressive, media-oriented style has created constant friction that Trump's demands for more aggressive tactics have exacerbated. Sources within Trump's legal operation report that Trump has become increasingly frustrated with Bove's performance since the disastrous first day of trial, believing that Bove's too deferential to the judge and too cautious. In cross-examination, Trump has reportedly told associates that he needs attorneys willing to fight aggressively rather than attorneys who seem intimidated by the court and by prosecutors. And he has specifically praised Habba's willingness to challenge the judge's rulings and to pursue confrontational strategies. However, legal experts note that Trump's preferences for aggressive confrontation reflect fundamental misunderstanding of effective criminal defense, which typically requires attorneys to maintain credibility with judges and juries through professional conduct, rather than through bombastic challenges that undermine attorney credibility and that create antagonism with fact finders who will determine guilt or innocence. The tension reached breaking point when Trump attended a strategy session yesterday evening where Bove presented plans for Pence's cross-examination that focused on narrow questioning designed to establish that Pence never explicitly told Trump that challenging the election was illegal, only that Pence believed he lacked authority to reject electoral votes. Trump reportedly rejected this strategy as too timid and demanded that cross-examination aggressively challenge Pence's credibility and suggest that Pence is lying about conversations to protect his own reputation. Bove responded that attacking Pence's credibility without factual foundation would backfire with the jury and would reinforce prosecution's case, but Trump insisted that Habba conduct the cross-examination because she would be more aggressive. Bove threatened to withdraw from the case if Trump insisted on ineffective strategy, leading to heated exchange where Trump accused Bove of being afraid to fight, and Bove responded that he would not commit malpractice to satisfy Trump's preferences for confrontation over effective advocacy. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely devastating for Trump's defense when you consider that this public breakdown occurred with the jury present in the courthouse and with spectators and media observing the dysfunction. While the sidebar conversations were supposed to be inaudible to the jury, court reporters and legal observers noted that some jurors appeared to be watching the defense table during the heated exchange, and that the attorney's body language and animated gesturing likely communicated to jurors that a conflict was occurring even if specific words were not audible. Jurors who observed defense attorneys fighting among themselves typically draw negative inferences about the strength of the defense case and about the defendant's ability to attract competent, unified legal representation, creating prejudice that affects verdicts regardless of the evidence. The fact that the conflict was serious enough to require a recess in chambers conference further signals to jurors that major problems exist with the defense, reinforcing narratives that Trump is difficult to represent and that even his own attorneys have lost confidence in his case. That's when it became clear. This courtroom squabble represents not an isolated incident that competent case management could overcome, but rather a symptom of terminal dysfunction where Trump's legal defense has collapsed beyond repair. The moment that crystallized this reality occurred when court resumed after the chambers conference and Judge Chutkan addressed the jury, stating that the court had needed to address certain procedural matters during the recess and instructing jurors not to draw any inferences from the delay or from anything they might have observed. Legal experts noted that such jury instructions typically have the opposite of their intended effect, drawing jurors' attention to events they might not have noticed and inviting speculation about what problems required judicial intervention. And the fact that Judge Chutkan felt compelled to give such an instruction demonstrates that she recognized the public conflict had created jury prejudice that needed to be addressed, even though addressing it likely made the prejudice worse. This legal team implosion sent immediate shockwaves through the already chaotic situation surrounding Trump's multiple simultaneous legal proceedings. When defense attorneys publicly fight during criminal trial where defendant faces decades of potential imprisonment, it creates a crisis that affects not only that trial, but all related proceedings where the same attorneys are attempting to coordinate strategy. Bove also serves as Trump's counsel in the Supreme Court disqualification litigation, and Habba has been involved in the impeachment defense coordination, meaning that dysfunction between them undermines Trump's ability to mount coherent defenses across all accountability mechanisms. The lack of communication and cooperation between lead counsel makes it impossible to ensure consistent messaging or to prevent one proceeding from creating problems in another proceeding. As when statements in one forum become admissions that can be used against Trump in other forums. This isn't the first time high-profile defendants have experienced defense team conflicts that played out publicly during trial, but the current situation is particularly damaging because of Trump's multiple simultaneous proceedings and because the conflicts arise from fundamental incompatibility between attorneys' approaches rather than from resolvable tactical disagreements. Think back to the trial of O.J. Simpson in 1995, where Simpson's dream team of defense attorneys included strong personalities who sometimes disagreed about strategy, but who maintained professional unity in court and limited their conflicts to private strategy sessions. The Simpson defense team succeeded despite internal tensions because attorneys recognized that showing unity before the jury was essential to maintaining defense credibility. Simpson's attorneys might have disagreed behind closed doors about whether to call certain witnesses or pursue certain strategies, but they presented united front in court that prevented jury from perceiving dysfunction. Then there was the trial of Michael Jackson in 2005 on child molestation charges, where Jackson cycled through attorneys and where defense team conflicts occasionally became public through media coverage. However, even in that case, attorneys maintained basic professional decorum during court proceedings and limited public disputes to press conferences and media statements rather than engaging in open conflict before the judge and jury. The Jackson trial demonstrated that even when defendants and their attorneys have conflicts, maintaining courtroom professionalism is essential to avoiding prejudice that affects verdicts. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget Trump's own prior experience with attorney conflicts during his business career and earlier legal troubles, where he frequently cycled through lawyers who either withdrew due to conflicts with Trump or who Trump fired for not being sufficiently aggressive. However, those earlier conflicts typically occurred in civil litigation or in transactional contexts where courtroom drama was less consequential and where Trump could replace attorneys without the price, severe time constraints, and procedural complications that apply in criminal trials. Now, however, Trump faces criminal trial where replacing attorneys would require convincing Judge Chutkan to grant continuance, which she has indicated she will not do, given that Trump's current situation resulted from his previous attorney's misconduct that Trump encouraged. The pattern across these precedents shows that defense team conflicts damage defendants' cases even when kept private, but that public courtroom conflicts create prejudice that is nearly impossible to overcome, and that signals terminal dysfunction in the defense. So what options does Trump have to address the defense team dysfunction? And what are the realistic prospects for salvaging his trial defense at this late stage? According to criminal procedure rules and Judge Chutkan's prior rulings, Trump could attempt to replace one or both conflicting attorneys, but would face significant obstacles in doing so. Replacing Bove as lead trial counsel would require Trump to find an experienced criminal defense attorney willing to take over a case mid-trial with virtually no preparation time, which is nearly impossible because competent attorneys recognize such situations as professional suicide. Replacing Habba would be easier from practical perspective, but would anger Trump, who values her willingness to pursue aggressive strategies, and would require explaining to the court why an attorney Trump specifically chose to include on his team needs to be removed. Attempting to replace both attorneys would almost certainly result in Judge Chutkan declaring a mistrial or granting a lengthy continuance. But the judge has signaled she views Trump's representation problems as self-inflicted and has expressed reluctance to reward Trump's attorney conflicts with delays that benefit him. Here's the kicker about the most likely outcome of the current dysfunction. Trump will probably be forced to continue with his current fractured legal team through the remainder of trial. With ongoing conflicts undermining his defense and with jury increasingly skeptical about defense credibility, Bove will likely remain as lead counsel conducting most examinations, but will face constant second-guessing from Trump and from Habba, creating tension that affects his performance and that prevents effective trial strategy. Habba will likely continue participating in limited ways while expressing frustration about being sidelined, creating the appearance of defense disunity that affects jury perceptions. The result will be defense that is technically adequate to avoid mistrial or appellate reversal based on ineffective assistance claims, but that is sufficiently dysfunctional that conviction becomes increasingly likely as trial proceeds, and as a cumulative effect of defense mistakes and conflicts undermines Trump's case. Don't go anywhere. The most explosive part is coming next, and here's what should alarm Trump about the broader implications of today's courtroom squabble beyond just the immediate impact on jury perceptions in his criminal trial. Media coverage of defense team dysfunction will dominate news cycles and will reinforce narratives that Trump is impossible to represent competently, that even attorneys who take on his cases eventually regret doing so, and that Trump's legal problems result, at least Partly from his own poor judgment and his conflicts with counsel, political opponents will use footage and descriptions of the courtroom and squabble in campaign advertisements, showing that Trump creates chaos even among his own attorneys, raising questions about his fitness to manage the federal government if he cannot manage his own legal defense. The coverage will be particularly damaging because it comes during the same 72-hour period when Trump faces Supreme Court a decision and Senate impeachment trial proceedings, creating narrative that Trump is losing on all fronts and that even his own team has abandoned confidence in his defense. Moreover, the public breakdown provides prosecutors with powerful rebuttal to Trump's inevitable post-conviction claims that he received ineffective assistance of counsel. Defendants who are convicted in criminal trials frequently file appeals or habeas corpus petitions claiming their attorneys were incompetent, and courts sometimes grant relief when attorney performance was demonstrably inadequate. However, when conflicts between defense attorneys result from the defendant's own demands for ineffective strategies, and when the defendant insisted on retaining conflicting attorneys despite their dysfunction, courts typically deny ineffective assistance claims on grounds that defendants cannot create their own ineffectiveness and then complain about it. Today's courtroom squabble creates extensive record showing that Trump's representation problems result from his own choices and from his demands that attorneys pursue strategies they believe are ineffective, making future ineffectiveness claims unlikely to succeed. This puts Trump in an impossible position where continuing with his current defense team guarantees ongoing dysfunction, but where attempting to change attorneys would be denied or would require delays that Judge Chutkan will not permit. On one side, he faces continued conflicts between Bove and Habba that undermine trial defense and that create jury prejudice affecting verdicts. On the other side, he faces reality that no competent attorneys would be willing to take over the case at this stage. Even if the court permitted substitution, Trump's only realistic option is to accept that his defense will be dysfunctional and to hope that prosecutors' evidence is insufficient to convince jurors beyond reasonable doubt, despite the problems with his defense, which appears increasingly unlikely given the strength of evidence, including recorded conversations and cooperating witness testimony. And here's the tricky part that makes today's breakdown potentially determinative for trial outcome, regardless of what happens in remaining proceedings. Juries pay close attention to defense attorney credibility and cohesion when evaluating whether to credit defense theories and whether to find reasonable doubt. When jurors observe defense attorneys fighting among themselves, they typically conclude that even the defense team does not believe in the case they are presenting and that the defendant must be guilty if his own lawyers cannot maintain unity. This inference operates at subconscious level, affecting deliberations regardless of jury instructions not to consider attorney conflicts, and creates presumption of guilt the defense must overcome through extraordinarily compelling evidence, which Trump's team lacks, given that most evidence supports prosecution's case. The courtroom squabble thus creates insurmountable obstacle to acquittal, even if prosecutors had weaker case than they actually have, making conviction virtually inevitable. As long as prosecutors complete their case presentation without major errors, legal and political analysts are calling today's courtroom breakdown the final nail in the coffin for Trump's trial defense, with the public conflict demonstrating that Trump's legal team has deteriorated beyond the point where effective representation is possible. Andrew Weissman told reporters that he has never seen defense team conflicts play out so publicly during actual trial proceedings, and that the damage to Trump's case is irreparable regardless of how well his attorneys perform going forward. And Weissman explained that juries make initial credibility assessments early in trials based on attorney conduct, and that today's squabble likely destroyed any remaining defense credibility, making it nearly impossible for jurors to give defense arguments serious consideration during deliberations, even if those arguments have merit. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even some legal commentators who have defended Trump throughout his legal troubles acknowledge that today's courtroom dysfunction represents a catastrophic failure of defense that makes conviction highly likely. Jonathan Turley stated that while he has concerns about aspects of the prosecution's case, defense team conflicts of the kind that occurred today are often dispositive because they signal to jurors that the defense has collapsed and that even the defendant's own attorneys have lost faith in his innocence. And Turley predicted that Trump will be convicted on most, if not all, charges unless prosecutors make serious errors during the remainder of their case presentation, and that Trump's best hope at this point may be to seek plea negotiations before the verdict, rather than waiting for conviction that could result in a harsher sentence. So let's break down precisely what today's courtroom squabble means for Trump's criminal trial, for his other legal proceedings, for his political campaign, and for his prospects of avoiding conviction and complete imprisonment. First, the immediate impact on the criminal trial is that jury has witnessed defense dysfunction that will color their perception of all subsequent defense arguments and evidence, even if Bove conducts effective cross-examination. And of remaining witnesses, jurors will view his questions through a lens created by today's conflict and will be skeptical about defense credibility. The prosecution can now present its remaining case with confidence that defense conflicts have undermined Trump's ability to create reasonable doubt, making conviction on at least some charges highly probable and conviction on all charges increasingly likely. Second, the dysfunction affects Trump's other legal proceedings because the same attorneys or closely coordinating attorneys are handling Supreme Court litigation and impeachment defense. Conflicts between Bove and Habba make coordination across proceedings impossible, creating risk that statements or strategies in one forum create problems in other forums. The Supreme Court is less likely to grant stays or to rule favorably for Trump when his own legal team appears chaotic and dysfunctional, because courts prefer to work with competent, stable counsel who can provide clear answers to judicial questions, and Senate Republicans considering whether to vote for full impeachment trial or for conviction will view defense team dysfunction as additional evidence that Trump is unmanageable and that accountability through impeachment may be necessary. Third, Trump's political campaign suffers devastating damage from coverage of courtroom squabbling that reinforces narratives about chaos surrounding Trump and about his inability to maintain stable professional relationships. Moderate voters who might have been willing to give Trump benefit of doubt will see that even his own attorneys cannot work together, raising questions about his ability to manage a presidential administration if he cannot manage his own legal defense. The coverage comes during the critical period when voters are making final decisions about primary preferences and when party delegates are assessing Trump's viability as nominee, potentially accelerating movement toward alternative candidates. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate implications for current proceedings, today's breakdown demonstrates fundamental character issues that extend beyond legal strategy disagreements to reveal Trump's inability to accept advice from professionals and his insistence on pursuing strategies that experts tell him will fail. The pattern of cycling through attorneys, conflicts with counsel, and public breakdowns has characterized Trump's entire legal and business career. But the stakes have never been higher than in current criminal trial, where decades of imprisonment are at risk. Trump's unwillingness or inability to defer to attorney expertise, even when his freedom depends on effective legal strategy, demonstrates judgment failures that should concern voters regardless of their political preferences. Because presidents must make critical decisions based on expert advice and must manage conflicts among advisors without descending into the kind of public dysfunction that occurred today, this scenario is generating intense discussion among legal ethics experts about attorney obligations when client demands ineffective strategies and when co-counsel conflicts make effective representation impossible. Bar associations and legal ethics scholars are debating whether Bove and Habba should withdraw from representation rather than continuing to serve client in dysfunctional arrangement that may not meet professional standards. Whether continuing to represent Trump despite the conflicts constitutes malpractice that could result in disciplinary sanctions, and whether judges should intervene more aggressively to ensure defendants receive effective representation, even when defendants themselves create the ineffectiveness through their demands and through their attorney selection. These debates will influence how attorneys approach representation of difficult clients and how courts manage cases where defense team conflicts threaten trial fairness. Meanwhile, Trump has responded to coverage of today's courtroom squabble with statements blaming both attorneys for the conflict while defending his decision to retain both of them. Trump characterized the dispute as minor disagreement between talented attorneys who both want to defend him aggressively and claimed that media coverage has exaggerated what was a brief sidebar discussion into major crisis. Trump stated that he has full confidence in both Bove and Habba and that they will work together effectively to prove his innocence at trial. However, sources familiar with Trump's private conversations report that he has expressed frustration with both attorneys, telling associates that Bove is too passive and that Habba is too undisciplined, but that he cannot find replacement counsel willing to take over the case at this stage. Trump has reportedly considered representing himself at trial, which would be his right under the Constitution. But attorneys and advisors have convinced him that self-representation would be disastrous given the complexity of the charges and the strength of the prosecution's evidence. The press conference Trump held this evening featured only Trump speaking without attorneys present, suggesting that defense team dysfunction has extended beyond courtroom conflicts to affect even basic campaign and media coordination. Trump delivered extended remarks about how the entire prosecution is political persecution, how the judge is biased, how the jury pool is tainted, and how he cannot receive fair trial in Washington, D.C. Trump claimed that today's sidebar discussion was normal trial management and that media has misrepresented what occurred to damage his campaign. Trump vowed to continue fighting in court and to prove his innocence regardless of obstacles created by biased prosecutors, biased judges, and media coverage designed to prejudice potential jurors. Trump notably did not defend or praise either Bove or Habba by name, suggesting that his confidence in his legal team has eroded despite his public statements of support. Stay with me. What comes next will completely change how you view this situation. Here's what makes today's courtroom breakdown so revealing about Trump's broader situation and about the impossibility of his maintaining political viability while facing criminal trial, impeachment, and disqualification proceedings simultaneously. The squabble demonstrates that Trump cannot effectively manage even his own legal defense when that defense requires coordinating multiple attorneys across multiple proceedings with consistent strategy and messaging. If Trump cannot manage a legal team of fewer than 10 attorneys handling related cases, how could he possibly manage a presidential administration with thousands of appointees handling vastly more complex policy and national security challenges? And the courtroom chaos provides a microcosm of what Trump's governance produces: constant personnel conflicts, inability to accept expert advice, demand for loyalty over competence, and public dysfunction that damages institutional effectiveness. Moreover, the breakdown reveals fundamental unsuitability for office that extends beyond specific legal questions about whether Trump engaged in insurrection or obstructed justice. Even voters who might be willing to overlook Trump's alleged crime should be concerned about demonstrated inability to work effectively with professionals to manage complex operations without descending into chaos and to maintain stable relationships with advisors who provide uncomfortable truths rather than preferred answers. These character defects create governance problems regardless of policy positions, because effective governance requires exactly the kinds of skills Trump has consistently failed to demonstrate. Throughout his business career, his presidency and his current legal troubles, legal experts immediately identified today's breakdown as likely marking the end of any realistic hope Trump had of avoiding conviction in his criminal trial. Barbara McQuaid explained that defense team conflicts visible to the jury create insurmountable credibility problems that make acquittal nearly impossible regardless of evidence, and that Trump's best option at this point is to attempt plea negotiations that might limit his sentence, even though pleading guilty would have devastating political consequences. McQuaid noted that continuing to trial when conviction is nearly certain risks maximum sentences on all counts, while negotiated plea might result in reduced charges or sentencing recommendations that limit imprisonment, though they would still likely result in substantial prison time given the seriousness of the charges. This goes far beyond affecting the outcome of Trump's criminal trial. It demonstrates that Trump's entire approach to legal and political challenges has been counterproductive, that his instincts for confrontation over cooperation have created unnecessary enemies and conflicts, and that his inability to accept professional advice has resulted in catastrophically poor outcomes that competent counsel might have avoided. The courtroom squabble provides definitive evidence that Trump's problems result not merely from biased prosecutors or partisan judges, but from Trump's own choices and from fundamental character flaws that make effective representation impossible, even when talented attorneys attempt to help him. If this blows your mind, hit that like button right now. Here's the situation in the starkest possible terms. Trump's legal team engaged in public courtroom squabble during criminal trial. Lead attorney Bove and co-counsel Habba fought audibly about trial strategy and attorney competence. Judge Chutkan required emergency chambers conference to address dysfunction. Jury likely observed conflict, creating prejudice affecting verdict. Defense team conflicts result from Trump's demands for ineffective aggressive strategies and from incompatible attorney personalities. No realistic options exist for replacing attorneys or repairing dysfunction. Criminal trial continues with defense credibility destroyed. Conviction appears increasingly inevitable. Political damage from courtroom chaos reinforces narratives about Trump creating dysfunction, and the squabble demonstrates character defects that extend beyond legal issues to raise fundamental questions about fitness for office. When defense attorneys engage in public conflict during criminal trial, it signals that the defense has collapsed beyond the point where effective representation is possible, and that conviction is highly likely regardless of the underlying evidence. The courtroom squabble today demonstrated that Trump's legal defense has reached terminal dysfunction where even basic professional cooperation has become impossible, making his conviction virtually certain barring extraordinary prosecutorial errors or jury nullification. Keep a close eye on remaining trial proceedings as prosecutors present additional witnesses and as defense team attempts to overcome credibility damage from today's public conflict. Judge Chutkan will likely monitor defense team interactions closely to prevent additional disruptions, but cannot repair the damage already done to Trump's case. Jury will evaluate remaining evidence through lens created by defense dysfunction. And Trump's prospects for avoiding conviction have diminished to the point where the question is no longer whether he will be convicted, but rather on how many counts and what sentence he will receive. Before we go any further, smash that subscribe button so you never miss content like this. Here's precisely where things stand right now in unambiguous terms. Defense team engaged in public squabble, damaging Trump's case irreparably. Jury observed dysfunction, creating credibility problems. Judge intervened to prevent further disruption. Attorneys continue representing Trump despite conflicts. No options exist for repairing defense dysfunction. Trial continues toward likely conviction. Political damage compounds legal problems, and the chaos that unfolded in real time demonstrates Trump's unsuitability for office regardless of specific legal outcomes. This isn't just another difficult moment in a challenging trial that skilled attorneys can overcome through better preparation or adjusted strategy. This represents a complete breakdown of defense capabilities where internal conflicts have destroyed credibility and made effective representation impossible. What happens in remaining trial days will determine Trump's legal fate, but today's squabble has already determined that conviction is highly likely and that Trump's political future depends on outcomes in impeachment and Supreme Court proceedings rather than on any hope of acquittal in criminal court. The squabble occurred, the damage is done, the conviction appears inevitable, and the chaos demonstrates character defects that make Trump fundamentally unsuitable for presidency, regardless of voters' policy preferences or partisan loyalties, and the courtroom breakdown has never been more public. The defense dysfunction has never been more complete, and the chaos that unfolded today has sealed Trump's fate in ways that make conviction nearly certain, regardless of what remains in the trial. Pause for a second and hit that like button if you're finding value in this comprehensive coverage.